Welcome back, everybody. And we're very pleased to have our first keynote speech presentation of the conference with Jayna Kothari. And actually, Panos Kapotas will be chairing, from Portsmouth University, will be chairing this session. So I think I'll just hand the floor over to you, Panos, to introduce Jayna and proceed.
Thank you very much. Thank you, Kelly. It's a pleasure to be here in virtual Hong Kong. As Kelly noted, I'm based in the UK at Portsmouth University, but as you can see from the background behind me, I'm currently in Greece in the true spirit of this global event. Let me use the cliche and say that Jayna Kothari need no introduction for most of us, but allow me to offer a quick selection of highlights from her illustrious career for those of you that might not be familiar with her work. Jayna is a senior advocate in the Supreme Court. She practices in the Supreme Court of India. She's also a co-founder of the Center for Law and Policy Research. She has written extensively on issues of equality and anti-discrimination law, including a monograph on the future of disability law in India. But most importantly, in my view, Jayna is someone whose work has a concrete impact improving the lives of people. She has argued constitutional challenges to Section 377 and a case on adultery, which were both decriminalized before the Indian Supreme Court. She has argued the independent thought case in which the Indian Supreme Court recognized child marital rape as a criminal offense. And she has also been instrumental in drafting an equality bill for India, the Equality Prohibition of Discrimination Bill of 2021. Without any further ado, I'd like to give the floor to Jayna for the next 30 minutes. Before I do, I should also say that we'll have ample time for Q&A at the end. Jayna, it is an absolute privilege to have you with us for the first keynote. The floor is yours.
Thank you so much, Panos, for that generous introduction. Good morning or good afternoon to everyone who's here, to the members of the Berkeley Center on Comparative, Equality and Anti-Discrimination Law and the University of Hong Kong Faculty of Law, the Center for Comparative and Public Law, the Human Rights Hub and the Equality Rights Project, to my wonderful chair, Panos, participants and everyone else joining in. I'm really honored to be invited as one of the first keynote speakers at this annual conference of equality law. This entire conference and the themes and the topics that are proposed to be discussed here are really quite exciting. And I do wish we could have been doing this in person, but I guess with the pandemic, we'll have to remain content with an online conversation. So as the theme for this entire conference is on equality law, I've decided to focus my keynote presentation today on new directions for equality in a post-COVID world. There are two reasons why I'm focusing on this theme. The first is that even prior to COVID, I think equality law has been undergoing tremendous change and has demanded a complete reimagining of how we understand equality and discrimination. And secondly, the COVID pandemic has hastened the need for such a response and has forced us to look at discrimination and exclusions that we would not have perhaps seen before, and has ignited an urgency to address inequality that perhaps would not have come had it not been for the pandemic. Let me begin by really laying out the impact that the pandemic has had on equality around the world. The UN General Assembly acknowledged that the poorest and the most vulnerable were the hardest hit by the pandemic. And the UN Secretary General has noted that the pandemic is highlighting deep economic and social inequalities and inadequate health and social protection systems that require urgent attention as part of the public health response. The World Bank states that the COVID-19 pandemic has exacerbated global income inequality, even reversing the decline of the past 2 decades. This increase in inequality caused by the pandemic may become entrenched as pandemic-induced disruptions to education and the disproportionate adverse effects on low-income households may worsen intergeneration mobility. The ILO, moving on from the World Bank, the ILO states that in India alone, more than 400 million people risk sliding into poverty because of reliance on informal work. Lockdowns made the digital divide more apparent as billions of people who did not have reliable broadband internet ended up limiting their access to work or education. With school closures and the divides in digital learning, the UNDP estimates that effective out-of-school rates could reduce to levels which were not seen since the 1980s. Vulnerable groups of young girls in India, for example, has seen an increase in child marriage and dropping out of school. Most importantly, women have been particularly exposed during the health crisis. They have been the bulk of first healthcare responders, working from home, which led to shouldering an even greater burden of housework and childcare, and evidence the world over shows that domestic violence was surging worldwide as a result of the lockdowns. The implications of the pandemic for LGBTQI people around the world has also been extremely severe. LGBTQ persons have always been vulnerable, but in times of crisis like this, especially in places where health systems have been weak, they have not been able to access services, which has only worsened their vulnerabilities. With all these themes of the pandemic and knowing how it has impacted vulnerable communities, how do we look at equality? I will be dividing my presentation into 2 parts. In the first part, I will talk about new protected grounds or characteristics that the pandemic has compelled us to think about for equality law. And in the second part, I will speak about how we perhaps need to reimagine substantive equality itself. So in the first part, I speak about new categories of protected characteristics and new forms of discrimination that we need to recognize. In most constitutions and equality legislations the world over, the common protected grounds on which discrimination has been prohibited have mostly been sex, race, color, language, religion, caste, political or other belief, national or social origin, property, birth, or other status. In some cases, disability as well. But COVID made us see how many other different protected characteristics were facing the brunt of the pandemic due to their inherently unequal status. And these new protected characteristics have become glaringly visible to us, while they were perhaps invisible earlier. One such glaring ground is that of poverty or socioeconomic disadvantage. Further, within the fields of employment, the status of platform or gig workers was not even recognized earlier, and COVID exposed their unequal status to us. And a third aspect we need to perhaps address most urgently is the recognition of intersectional discrimination. So these are the 3 categories I will be discussing in this part. When we look at poverty, the pandemic made it extremely clear that the costs of the pandemic were borne disproportionately by the poor. Low-income populations were more exposed to health risks and more likely to experience job losses and declines in well-being. And these effects were even more concentrated in other minorities who were economically disadvantaged. People in poverty face systemic discrimination because most societies still remain deeply segregated by wealth. During the pandemic, we saw that children born in disadvantaged families were declined equal opportunities. Their chances of achieving a decent standard of living was significantly diminished only by the fact that their parents were poor. We saw that with the lack of access to education because of not having online access during the lockdown. Poverty is perpetuated by the lack of access to health, housing, education, and employment. And therefore, if we really want to address it, you need systemic remedies, such as investment in early childhood and education and care, inclusive education, provision of a universal basic income for young people, and perhaps some have argued even an increased taxation on inheritance. So if we really need to address discrimination, there is also a need to prohibit discrimination on the grounds of poverty or socioeconomic disadvantage, which is key to breaking the cycles that perpetuate poverty. Most legislations on equality currently do not address poverty or socioeconomic disadvantage as a prohibited class. And perhaps the pandemic will lead us to exploring such new prohibited categories. The second area I'd like to highlight is the need to recognize platform or gig workers. With the lockdown the world over, millions of people were locked up inside their homes and dependent on platform or gig workers to deliver their groceries and essentials. Gig workers, on the other hand, were exposed to heightened health risks, abuse, violence, police harassment, low pay, and completely unstable jobs. Most platforms typically classify workers as independent contractors and not really employees, and therefore gig workers were generally excluded from the scope of labor rights. This led to a corrosive effect on the working standards of platform workers. And some of their core concerns have been low pay, poor working conditions, unreasonable contracts, and a complete lack of representation, lack of any safety or welfare measures. Due to the issues raised during the pandemic, courts in many countries have recognized the status of gig workers as workers entitled to equal benefits and basic equal rights within employment. And therefore, our employment laws need to build in non-discrimination and equality measures for such informal workers to include platform or gig workers. And thirdly, I'd like to focus on the need to recognize intersectional discrimination. What COVID brought home very glaringly is how prevalent intersectional discrimination was experienced during the pandemic. The experience of persons marginalized on multiple accounts was aggravated, whether it be women migrant workers in India, children from marginalized backgrounds who were excluded from online education, or Dalit women facing increased violence. These categories of vulnerable groups who were facing vulnerabilities due to multiple forms of discrimination faced the most aggravated forms of violence. Transgender persons were already marginalized, but with the compounded effect of the pandemic, they found themselves abandoned and struggling to get even access to basic rations and medical care. And this was aggravated for trans persons from Dalit Adivasi backgrounds or with disabilities or affected by HIV. Our equality legislations and welfare measures and schemes and benefits have not taken into account the recognition of intersectionality. And so unless we include an intersectional perspective, our responses to discrimination will be highly inadequate. And here I would like to refer to two recent Supreme Court decisions from India, where intersectionality was raised and recognized. In the case of Navteej Johar, a case which I argued on the decriminalization of Section 377, for the first time, the Indian Supreme Court referred to the term intersectionality in the context of Article 15, which is the article in our Constitution on non-discrimination. The court emphasized that discrimination based on sexual orientation and sex is based on stereotypical notions of sex and gender roles and should be understood from an intersectional nature because sex cannot be said to operate in isolation from other identities. And in another recent decision, again of the Indian Supreme Court, titled Patan Jamal Wali versus State of Andhra Pradesh, which was a criminal appeal in the case of a rape of a Dalit girl with disability. Again, the Indian Supreme Court elaborated in great detail on the need for an intersectional approach. The court, in fact, argued that multiple marginalities that the victim in this case faced should be taken into account And in order to do so, it relied on the work of Kimberly Crenshaw, who was really the architect of the word or the term intersectionality, and on the work of the Combahee River Collective Statement, which focused on this intersectional discrimination faced by Black women in the US, to understand how multiple sources of oppression operate cumulatively to produce a very specific experience of subordination for a Dalit woman with disabilities. And the court in this judgment made a call that the criminal justice system should be more responsive to intersectional discrimination. And so I wanted to highlight this because I think the pandemic has heightened the urgency for a need for an intersectional response to equality. I now move on to the second part of my presentation, and here I will lay out why perhaps we need a reimagining of our understanding of substantive equality, and if we do need such a reimagining, how could that be? Now, while our understanding of equality has moved from formal equality to substantive equality, I would argue that even our present understanding of substantive equality needs an expansion. Substantive equality as a concept moved away from formal equality, which believed in treating likes alike, by embracing differences among human beings and paying attention to the actual conditions of members of disadvantaged groups. It recognized that treating people alike, despite pre-existing disadvantages or discrimination, can simply perpetuate inequality, and therefore the standards of formal equality were not enough. As Amartya Sen argues, equal consideration for all may demand very unequal treatment or special treatment in favor of the disadvantaged. And so therefore, substantive equality looks beyond the limits of identical treatment to the measures which may be required in order to counter disadvantage and to facilitate equality, and requires difference resulting from factors such as disability or gender to be acknowledged and to bring about or demand different treatment where any identical treatment would cause a disadvantage. Here, Professor Sandra Fredman's model of substantive equality or transformative equality has been quite important. She introduced a four-dimensional model of substantive equality, which included redressing social and economic disadvantage, addressing stigma, stereotyping, prejudice, and violence, enhancing participation, and accommodating difference by achieving structural change. Building on this four-dimensional model of substantive equality and strengthening it, I would argue that we perhaps need a reimagining of and strengthening of this substantive equality model. And here I borrow the term coined by Judith Butler, which she terms radical equality, which would include in the conceptualization of equality the freedom from violence and fear, where every person in life is valued equally, and therefore the recognition of equal worth and dignity of each person, and the recognition of people's different needs and removal of barriers and limits to what people can do and be. I would like to elaborate this reimagined version of equality and some of these concepts. So the main themes I would like to raise here are reasonable accommodation, recognition of equal worth, freedom from violence, and the recognition of systemic or structural forms of inequality. I'd first like to focus on reasonable accommodation. The reasonable accommodation concept is a concept that was introduced by the disability rights movement and the UN Convention on the Rights of Persons with Disabilities. And reasonable accommodation was defined in the CRPD as any necessary and appropriate modification or adjustments to ensure the enjoyment or exercise on an equal basis with others of all human rights and freedoms. This concept of reasonable accommodation, I would argue, is not just a requirement for disability rights or people with disabilities, but what we need to strengthen our understanding of equality for all protected groups. It is the obligation to take differences into account as part of the realization of equal treatment, which would entail several positive obligations. Thus, reasonable accommodation would not be conceived as an exception to the prohibition of discrimination, but as an intrinsic element of the duty of equal treatment. And any refusal to provide reasonable accommodation would constitute discrimination. Therefore, temporary special measures which are necessary to either accelerate or achieve equality of persons from any protected class would not be considered as discrimination. In fact, it would be part of the positive duty to provide equality or equal treatment. So therefore, while reasonable accommodation for people with disabilities may require workplaces to put certain measures in place, reasonable accommodation for transgender persons at universities and educational institutions would require, for example, gender-neutral accommodation or hostels. Reasonable accommodation for religious minority students would require allowing them to wear a headscarf or a hijab in addition to the school uniform. And we're seeing even these basic requirements not being provided in many contexts, India especially. How do we strengthen equality by internalizing a requirement of reasonable accommodation for all protected classes? Secondly, is the need for respect for equal worth and dignity of each person. The recognition of the equal worth and dignity of each person has been a core facet of equality, and the connection between equality and dignity has been made by constitutional courts in many jurisdictions in India, Canada, and South Africa. And this principle is rooted in the dignity argument that each human life has intrinsic value, and that if people from a certain group have not been afforded equal treatment, the root of such unequal treatment is the non-valuing or non-recognition of the equal worth of any person. The argument of dignity and equality is experienced or is articulated in the stereotype or anti-stereotype argument that many courts the world over have been articulating. In India, for example, there has been a recent spate of Supreme Court decisions where stereotyping, especially on the grounds of sex, has been recognized as a form of inequality and connected to the non-recognition of the dignity of a person on the basis of sex. And therefore, the argument made is that stereotyping is subordination of people, and where a person is stereotyped or subordinated, her worth and life is not valued as equally. So how do we bring in the recognition of dignity and equal worth of all persons within our understanding of equality? The third concept I'd like to focus on is freedom from violence. Now, the four-dimensional model of Professor Friedman of substantive equality does refer to addressing violence, but I would argue that it's perhaps not enough, and we need to strengthen it by encompassing the need for freedom from violence. And why is that important, or what do we perhaps mean by that? We've seen during the pandemic a shocking emergence of violence, both state-supported violence and violence by private actors against historically marginalized communities. Whether it be the killing of George Floyd and police violence against African Americans in the US, or the gruesome incidents of sexual violence and killings of Dalit women in India, or attacks on religious minorities the world over. All of this has increased during the pandemic. Asian Americans have experienced increased violence in the US during the pandemic. And, why has this happened? We have seen that governments the world over has used the pandemic and the lockdowns to pass draconian laws targeting minorities, and the protests that ensued led to an unleashing of violence by state authorities against minority groups. And in many contexts, religious violence increased during the pandemic. Religious violence was exacerbated by conditions of poverty and destitution, which was caused by the pandemic. And for example, in India, cases of religious and caste-based violence in 2020 nearly doubled from 2019. Surprisingly, even as the country witnessed lockdowns and limited outdoor activities. The threat and the increase in religious violence was also because of the perceived spread of the violence through religious practice and religious pilgrimage, and it led to resentment towards certain communities, which ended up facing a backlash. The most intensified forms of violence during the pandemic was really faced by women. Domestic violence, sexual violence by women, marginalized especially by caste, race, or religion, and violence against trans and intersex persons. India especially has been witnessing a spate of honor crimes and honor killings over the last 2.5 years. Judith Butler, in her recent work on nonviolence, argues that because violence operates as an intensification of social inequality, a commitment to equality must include a commitment to nonviolence. And I would borrow from some of her work on this. And to explain the concept of how equality and nonviolence are linked, she argues that the violence faced by some people is because some lives are clearly more valued than others. And therefore, it is inequality that implies that certain lives will be more tenaciously defended or protected than others. And hence, we need a conceptualization of equality, which would necessarily have to include a commitment to nonviolence. And this does not mean just the absence of violence. Nonviolence would mean a sustained commitment to freedom from violence and fear. How can people, especially people from most vulnerable groups, live without the fear of violence? And how can we make this an inherent part of our understanding of equality? And finally, the need to recognize systemic or structural forms of discrimination. Systemic discrimination has been described as discrimination against some groups that is pervasive, persistent, and deeply entrenched in social practices, often involving actions that are unchallenged or indirect discrimination. This could be laws, policies, practices, cultural and social attitudes, which could cause disadvantage to some groups and privileges for other groups. Tackling such systemic discrimination usually requires a more comprehensive approach with a whole range of laws, policies, programs, and special measures. We would need affirmative action programs and targeted policies to address historic inequalities or structural inequalities in race, gender, and caste that have often been reinforced by social norms. And therefore, we need to reimagine equality that addresses systemic or structural discrimination and aims to remove it. Again, over here, I would like to refer to a recent decision of the Indian Supreme Court in Nitisha versus Union of India, where for the first time promotions for women within the army were made, and the practice where women were not getting promotions was held to be discriminatory. And the Supreme Court recognized, and I quote, that in light of the systemic discrimination that women have faced in the army over a period of time, to call for the adoption of a pattern of evaluation that accounts and compensates for this harsh reality is not to ask for special or unjustified treatment. Rather, it is the only pathway for the attainment of substantive equality. To adopt a symmetrical concept of equality is to empty the anti-discrimination guarantee under Article 15 of all meaning. And so the court recognized that asking or mandating special measures is actually needed if we want to address systemic or structural discrimination. And therefore, the mere granting of compensation or relief to a certain individual may not have any real impact. And systemic discrimination needs often larger, forward-looking, perhaps non-pecuniary remedies in legislation and by the courts so that effective protection is given against discrimination, which is at a more structural level. So therefore, for example, accessibility, if we talk about persons with disabilities, accessibility has to be built into systems and processes without referring to the needs of a single or individual person. Gender, caste, and race equality in organizations with respect to promotions, equal pay, and benefits must be built into organizational structures if we want to address structural discrimination. Going back to violence, Butler again discusses violence and structural inequality and the links between the two. And she argues that social structures or systems, including systemic racism, are inherently violent, and that even the act of physical violence, the physical strike, and I quote, to the head or the body is an expression of systemic violence, and therefore we have to address the relationship of violence to systemic inequality. And this argument is, I think, extremely useful to understand systemic violence that women face. In India, we have seen over the last 2 years an increased amount of violence, gruesome violence against Dalit women facing sexual assault and murder. And how do we link that to structural forms of discrimination on the basis of caste and gender? And therefore, our understanding of substantive equality has to encompass such structural and systemic discrimination and therefore find ways to remedy it. To conclude, I think I'm more or less within my time. I would conclude by saying that we need new thinking and directions on understanding equality. The pandemic has exposed glaringly the inequality of our world and our society, and exposed to us that perhaps our earlier models of equality were not enough. Our constitutional frameworks and legislations have to make way for new protected classes and new remedies. Our courts have to address structural and systemic discrimination. Our law enforcement authorities have to view violence and atrocities not just as criminal offenses, but as forms of structural inequalities and take measures against it. And I hope that dialogues such as this conference help us structure such new frameworks of equality going forward. Thank you.
Thank you, Jayna, for a wonderfully rich, far-reaching, broad and comprehensive presentation on the new directions for equality law. I, for one, have frantically taken notes during your presentation to ask questions and pick your brain, but I'm not going to abuse my position as chair. Allow me to open the floor to everyone for questions.